top in the middle to the right of animation, right?
Oh, I see it. I got it. Yep, I'm good to go. All right. I don't know why I could not find that. I could not find that. Good morning. I am Elizabeth Ward Saxl with the Maine Coalition Against Sexual Assault. And in case you were particularly looking forward to it, I am not, as promised, Donna Strickler. But Donna has been one of my mentors since I began in this work. So I promised to try and do right by her. Many thanks to the Victim Advisory Board for putting this week together, and particularly to Kara for her coordination. What you're going to get from me today is my take on our shared history, which has been informed to some extent by getting to work with and hearing from some of the giants on whose shoulders we stand. Our founding mothers like Laura Fortman, Nancy Fatuma, Lois Reckitt, Marty McIntyre, Jane Root, and Francine Stark, who of course you heard from yesterday. Content considerations, just a reminder that we know that this movement was and is led by survivors who began this work and who continue to do it. So please do what you can to support yourself through this process. Oh, Donna, did you miss my shout out or do you get it? Did you hear it? I said, I can't be Donna Strickler, but she's one of my mentors, 20 years of it. So I'm gonna do my best by her.
Oh, very kind of you. I'm so happy you're doing it. And
all right. So as you know, sexual violence can happen to anyone, but it has a disproportionate impact on certain communities and in certain circumstances. Violence happens because of opportunity and power, and especially to those whom we dehumanize through racism and the like. Intersecting identities, as we know, and circumstances can further increase the risk of victimization. So, for example, people who are Black and trans and homeless face even higher rates of sexual violence. And I'm just hoping as we think a little bit together about our history and where we're going, that we can keep these disproportionately impacted populations in mind. And certainly this is by no means a comprehensive list, but I think is indicative of what we want to be talking about. I'd like you to try and keep this in the center of your view. So individuals with disabilities, particularly cognitive disabilities, sexually assaulted at a much higher rate than those without. Native American women, Black women, children, trans people. And a special shout out to Quinn Gormley for her research and Maine Transnet's research to give us Maine-based data related to sexual violence. The story of the anti-sexual violence movement often starts in the 1960s with the work of cis white women, but I think we need a broader view. As an aside, if you haven't taken the new advocate training, the sexual assault advocate training, please do, because one of the things that it really does a great job of is giving us a more complete look at our history. One of the facts that continues to amaze and inspire me about this work is that at some point, every sexual assault survivor's story I have ever heard, they talk about how they want to keep this from happening in the future, how they want to do something within their own life, be it small or large, to end sexual violence. I know our VWA friends with us today have often heard survivors mention one of the key reasons why they are engaging in the criminal justice system as being wanting to keep the person who caused harm from causing harm to others. This selflessness, this ability to look outside during a time of intense internal hurt is just deeply inspiring. And it's the reason why I know that the sexual assault movement here in Maine began here, unceded Wabanaki land, began when the first Europeans arrived. I know that Native survivors talked with one another about what was happening to them at the hands of Europeans and talked about how they could protect one another, how they could protect their children, how they could support other women, how people of two spirits could help support one another as they were experiencing sexual violence. And so though we don't have a historical record that neatly lays that out for us, for me, that's where the sexual violence movement began in Maine. We do have much more in terms nationally, in terms of the role that that women of color, and particularly Black women, played in the beginning of the anti-sexual violence work. We know the historical record tells us that in 1816, Harriet Jacobs published one of the first accounts by a survivor describing the sexual violence she experienced. And in 1866, Frances Thompson, a trans Black woman who may be one of the first ever to provide any testimony to Congress about sexual violence, she described what she experienced and witnessed during the Memphis massacre. And Ida Wells, Recy Taylor, Rosa Parks, all inspired many in our country to engage in the movement to recognize and end sexual violence. Those are the original shoulders on which this movement stands. Although women continued individual acts of resistance through the first half of the 20th century, the next wave of the anti-rape movement began in the late 60s and early 70s. This is where we start the traditional story on the heels of the civil rights and the student movements. Maine's first rape crisis centers formed in kitchens and then as small nonprofits in the late 70s, as survivors came together to seek ways to support one another and to end violence moving forward. Donna and and other people's friend, Marty McIntyre, began her work in the early 80s at the Lewiston-based center, which was at the time a donated office at Central Maine Medical Center, where she sat with a phone and a stapler and a pen and a pad. She still owns that stapler, and coordinated folks to sit by that telephone. And sometime around then, and we don't have a great record of exactly when, those emerging rape crisis centers began to sit together and formed the Maine Coalition on Rape, which is now known as the Maine Coalition Against Sexual Assault, which brings us to 1984. Wait, why 1984? And no connection with George Orwell, just want to say, except that this is stolen from a book cover of 1984. But aside from that, there's no connection. Why 1984? Because the first minutes I have of a Mikasa meeting were from October of 1984. So this is where my official record begins. In the October meeting minutes, our total assets at Mikasa stood at $63. That's hard to imagine today with a staff of 12 engaged in providing training and tools to providers and other partners, funding service provision through 9 or more agencies of different kinds across the state, and advocating for victim-centered public policy. And yet I am absolutely certain that those $63 were well spent by the Maine Coalition on Rape. The coalition, which included emerging rape crisis centers, the Women's Commission, which was a quasi-state commission. It actually was, Governor McKernan got rid of it and it was reformed about 10 years ago. So that's back. The coalition also consisted of Tri-County Family Planning at the time, and the Sex Offender Project of the Maine State Prison, among others, met together to share best practices and to support one another. Exactly what we do today, what we did this morning. With Donna and her colleagues. And they reported on buying a VCR to support school-based prevention programming, about creating support groups and training advocates, about community education and training professionals like CPS staff. Very well could have been the minutes of this morning. They talked about creating outreach materials and working with community partners. And they reported on the legislative work of the day, which is another reason why 1984, 1985 is a key date for me, because it is one of the biggest initial wins for the Maine Coalition on Rape legislatively. It was when the marital rape exemption was eliminated. So can we just dwell on this for another minute? 1984. Until 1985, it was legal for a husband to rape his wife in Maine. And in fact, also they had another lovely element, which was called the social companion exemption, which essentially, and I'm simplifying somewhat, if you agreed to go on a date with someone, you also sort of got that same marital exemption. If you agreed to have him buy you dinner, then it was actually going to be legal for him to also sexually assault you. So they got rid of that in 1985. Thank you so much, Maine Coalition on Rape. And while the scope and reach of Maine sexual assault support centers today is clearly vastly different, and also includes sexual assault providers like Maine Transnet, Immigrant Resource Center of Maine, and the providers of the Wabanaki Women's Coalition, I can't help but see the commonalities from those minutes with what we actually do today, right? In those reflected, we see providers meeting survivors where they are, providing support across the age span, being responsive to the unique community needs, building the capacity of communities to support survivors. I think one of the things that has always been true about Maine sexual assault support centers is they've always said, we don't have to be the only experts. We want others in our community to help in the work of supporting survivors, no matter where they are. They had, within those minutes, today we use the public health model of prevention, and it's a multi-level engagement from individual to community and beyond levels. And there they are in the minutes, individual intervention with kids in schools, community level prevention efforts, and of course, legislative work. And they were also from the very beginning, and this is a work that is obviously quite central to what Maine Coalition Against Sexual Assault does, is they were deeply committed to making change. That a core piece of what they have always done, what we still do today, is not just provide services, but to really work to change the environment in which we work. So they were training professionals, they were building relationships with community partners to build the kind of trust that you need to drive change, and they were advocating for public policy. And though it is not fair, just want to say, not fair to characterize a couple of decades worth of great work and life-changing work based on 2 pages of minutes. So let the record reflect, that is not fair. What feels like it's missing is a focus on our LGBTQIA2+ survivors and individuals with developmental disabilities, on our Wabanaki neighbors, on Black and Brown women, on incarcerated survivors, and those who are homeless. When I began this work with the coalition 20-some plus years ago, I think that the pervasive concept was our doors are open to everyone. Anyone can come through our doors. Today, our attitude is quite different. We recognize that there are many barriers to providing real, welcoming, comprehensive services for folks. And so today, I think where we're headed, we are on the road to, is working to turn our focus, to listen to those communities, to find better ways to support the survivors who are with them, either through those 1984 rape crisis centers. Donna's wasn't formed yet at that point. So we're doing better in Kennebec County, and or through organizations that are providing services for and by the communities that are trusted by them, like the Wabanaki Women's Coalition, like Maine Transnet, like IRCM, like Disability Rights Center, like Speaking Up for Us, and others. We are very proud to have IRCM as one of our partners. And I know Fatuma is here to talk a little bit about the history of their service provision within this frame and specific to sexual violence. And so I think at this point, I'll hand that right over to her.
Thanks, Elizabeth. That was great. Thank you. Thank you for including us, Kara. And I know you're presenting for us tomorrow at our sexual assault event too. So a shout out to IRCM. We have a big event scheduled tomorrow, which is part of our monthly, not monthly, but Sexual Assault Awareness Month event. And so we will be looking forward to some of you attending that. So I want to share a screen very quickly of a few slides myself. Can you see that? Yeah, thank you. Okay, so I wanted to just very quickly also follow Elizabeth, and in regards to speaking at the this theme, which is access, equity, and justice for all. We are based out of Lewiston and are rapidly expanding, and I think that's a good thing for us and the people that we serve. I'm going to try to do the slideshow. Did I do that? Okay. Okay. There. So it is important to really, I'm trying to see if I can get this on the side so that I can. All right. So it's important to recognize the path paved for culturally specific victim services and what we're doing today. First of all, it's important for us to acknowledge and must acknowledge the legacy of sexual violence and victim services. As a Black woman, Black and Brown women are affected at a higher level when it comes to sexual violence. For me particularly, and the people that we serve, who are immigrants, refugees, asylum seekers, and now to some extent, we have younger generation who identify as African-American coming through our doors. Sexual violence is exposed to us at a very young age, starting with female genital mutilation, coming from a background of war. All we know is sexual violence. If you're a girl, if you're a woman, that's what you know. If you're a boy, to some extent, that's what you're exposed to and that's what you know. And so it encompasses our livelihood, who we are, but we don't recognize that that is sexual violence until we get exposed to countries such as this country. And so the stigma, the bias, and the lack of protective measures are obstacles to really getting the help that we need. Black and Brown women have advocated against sexual assault and sexual violence, provided victim services despite these obstacles. And to Elizabeth's point, I think there's a lot that Black and Brown women do around the world that often is not necessarily known of or acknowledged. And therefore, you know, Anita Hill, those major figures that really put us to where we are today and had sexual violence at a spotlight where it became a subject that people will talk about, not shy away from. Do we have a lot of work to do? Absolutely. But I think that work on a personal level and on a social level, the fight against you know, misogyny and keeping victims from justice, all of that work, women who are Black and Brown, you know, have been part of it. They've been critical to it. They were the centerpiece. And so we as IRCM know that every day we are standing on the shoulders of a lot of giants. Giants who may not necessarily have access to justice, but knew what to fight for so that generations to come, they will also, and we will also access services. So our culturally specific services is really victim-centered. And in 2001, Lewiston, Maine, Auburn, Maine, and the state of Maine was seeing a lot of Somalis. These Somalis were coming from all over the country. And they didn't ask for permission, they just showed up. They showed up on snowy days. they showed up with bright colors of clothes, with flip-flops, and they just showed up. And so Mainers were like, who are these people? Keep in mind, it's on the eve of 9/11. So you're Muslim, you are, you're very obvious that you're from away. You're not wearing snow boots. You've never owned a snow boot in the past. When you wear your bright colors, I actually had a woman stop me at Hannaford's and said, hey, why are you wearing bright yellow and orange? Do you think it's Halloween? And I'm like, what is Halloween? Are you kidding me? And so, it was just a time where so much change was happening. And yet we were transforming the state of Maine, not knowing at the time what we were doing. And so we saw many women and children. There were a lot of barriers and obstacles. It was hard to receive proper access to services that are culturally and linguistically specific. It was a challenging time. The host community wasn't prepared for us. Neither did we know what we were getting into. And so the state of Maine had the Refugee Advisory Council, and they invited us to come and speak. And there they were like, we are seeing a huge influx of Somalis. Can you, Fatuma, come work for us? And I was like, I'm very pregnant. It felt like every year I had a baby, and for real, for the last 20-some years, I've been having babies. I've got 4 boys, 4 girls. And so at the time I was like, no, I'm gonna have a baby. But the more we looked at our struggles and the more we looked at the gaps of services in my early 20s, the more we felt like, oh no, this host community and the state is not equipped to serve what we are seeing, what the needs are, the gaps. And in it, for me, what I actually looked at was this gender-based violence, this lack of empowerment. Don't get me wrong, immigrant women, people who have gone through refugee process are resilient and courageous, because if you've gone through war and survived, there's nothing that can come your way, because you're going to be that resilient and courageous person. That said, these are services that are not really equipped to serve or designed for us. And so we looked at targeted resources and services. And in 2002, August 2nd, 2002, a shout out to IRCM. We're going to be 20 years old this year. So thank you. So, a lot of goosebumps. Thank you. So that, under the fiscal agent of Catholic Charities and Community Concepts, with $40,000 from the Department of Health and Human Services, we hit the ground. And our goal was to support, empower, uplift the victims and survivors who didn't have the skills or tools to come forward on their own. And somehow, fast forward around 2006-07, this lady called Elizabeth just showed up, and I was like, okay, what does she want? Who is she? And we will go to this restaurant called the Red Sea, Elizabeth. We will eat lunch and we will talk, and she will come back and come back and come back. And therefore, our services, we're going to look at the people that we serve. We knew that we had barriers for the survivors of sexual violence. We knew that we needed a different avenue. We knew that there had to be change. And therefore, and I know I'm out of time, we've got only 3 minutes. And so just very quickly, lack of knowledge and information about the legal system. There's a lot of immigration issues. We don't trust law enforcement and the judicial system, because that is the system that will rape us and say we will protect you at a war zone. There is no place in my community that a victim, a survivor of sexual violence can say, I was raped, I went through this, and I need services. It's such a huge stigma. But today, when you come to our gender-based violence office, there's a lot of traffic, and that makes me proud. No matter where we are, from Bangor to York County, it's there. It's there. So I think there's a lot of progress, there's a lot of access, there's a lot of equity that is is really on the right path. Acknowledging, accommodating the unique experiences, making sure that there's intergenerational and cross-cultural support. That's very important because I've got girls, 4 daughters, very proud. I've taught them to be independent. When they speak back to me, I'm often saying, hey, don't say that. And they're like, are you kidding us? You taught us to be that. And so I think there is a lot of independency, empowerment, that cultural shift that young people from our background must receive while we embrace older people like me so that we can still have access to services. So the future holds a lot for us. There's so much, and we've got 1 minute. So Elizabeth, I'm going to stop at that, and I can share these slides too, because I know our 30 minutes are up. Any questions?
Wow, yes. Questions for Fatuma or questions for Elizabeth?
And Donna too.
Yeah. Yeah. I'm blown away, by the way, both of you, how much information you got out in such a clear way in such a brief amount of time. Really thoughtful. Thank you. Yeah, does anyone want to chime in with anything? And you can message me directly as well if you want. Okay. Wow. So we're gonna switch gears just ever so slightly. We also have with us today the Honorable Judge Eric Mehnert. I'm sorry, I have a cold today. Who is joining us. He's the Chief Judge of the Penobscot Nation Tribal Court, and he's going to talk about some exciting expansions to tribal court jurisdiction that are coming about as a result of both some federal changes with the Violence Against Women Act and also some state law changes that have enabled that federal legislation. And so I'm going to turn it over to Judge Mehnert, but if Fatuma and Elizabeth, if you're willing to stay on as well, we may have questions for you at the end as well, that would be amazing. So thank you very much, and we'll welcome Judge Mehnert now.
Thank you. I appreciate you having me here today and the opportunity to enjoy a conversation with everyone. I know when the magistrate judge here is a woman by the name of Rhonda DeConti, and she tells me if I talk too long, I get really boring. So please, if you have questions, please chime in. I prefer to have a conversation rather than a lecture. So if you have any questions at all, please raise them as we go, and we'll go from there. I know that Donna Brown had previously presented, and she had given you some of the statistics concerning Native American women and what led to the initial VAWA. Those statistics are from the Department of Justice, and they tell us that 34%, that is more than 1 out of every 3 Native American women, will be raped in their lifetime. That 61%, more than 6 out of 10, will be physically assaulted in their lifetime. And on some reservations, Native American women are murdered at 10 times the national average. 86% of the rapes and sexual assaults in which the victims are Native are committed by non-Natives. 86% of which, in which the rapes and sexual assaults in which the victims are Native are committed by non-Natives. 68% of the aggravated assaults against Natives are committed by non-Natives. And yet, until recently, those individuals could not be tried in a tribal court. The law used to be that non-Natives who committed assaults against assault and battery against Native American women were subject to misdemeanor prosecution in the federal courts. That is a result of some jurisdictional laws that came about. The problem with that was that the U.S. attorneys declined to prosecute some 67% of the sexual abuse cases that happened in Indian country. In fact, in 2006, which is the latest data that we have, the U.S. attorneys prosecuted only 24 misdemeanor assault cases sexual assault, domestic violence assault cases in Indian country throughout the United States. In 2007, the U.S. attorneys only prosecuted 27 across Indian country. Those were the statistics that led to the move to enact the reauthorization of VAWA, which expanded tribal court jurisdiction over category crimes called special domestic violence criminal jurisdiction. Real briefly, the history of tribal jurisdiction is in 1830, there was a case called Worcester versus Georgia. The Supreme Court of the United States said, no law runs on tribal land, but tribal law. If you go in and it's a separate sovereign, if you commit an offense on tribal land, you're subject to the tribal laws. In the 1870s, there was a case called In re Crow Dog. In re Crow Dog was a case where an individual, one native, killed another native. The native tribes said, this is what we decide is a penalty for that. And the U.S. attorney said, no, I would prefer to have something different. I want to hang him rather than allow the tribal penalty. Case went up to the Supreme Court. The Supreme Court said, no, the law is clear. No law runs on tribal land, but tribal law. The tribe has spoken. That's what it is. Congress refused to accept that, and they enacted what's called the Major Crimes Act, which took 10 crimes away from the tribe's jurisdiction, and that's what led to the original erosion of tribal jurisdiction. 1978, there was a case that came along called Oliphant. Oliphant was a white man who committed an offense on tribal lands, on the Suquamish tribal lands, and was prosecuted by the Suquamish in the Suquamish tribal court system. The district court and the Ninth Circuit Court of Appeals both said, nope, that individual, he appealed for a writ of habeas corpus saying he shouldn't be prosecuted on tribal lands. Both of them said, no, you're subject to tribal court prosecution on tribal lands. The Supreme Court in a 5-4 decision said, oh no, we're not going to allow non-natives to be prosecuted on tribal lands. And so that's the way it was from 1978 to 2013. In 2013, the Obama administration had moved through, in conjunction with the Tribal Law and Order Act, the federal reauthorization of the Violence Against Women Act. And at that point in time, the Violence Against Women Act, as passed by the federal government, included tribes, gave tribes special domestic violence criminal jurisdiction over non-natives, but in a very limited set of circumstances. And they set out some very specific rules. So if you're prosecuting a case in the tribal lands that included domestic violence, dating violence, or criminal violations of a qualifying protective order, and that the crime occurred within the tribe's Indian country, and the victim was an Indian, and that the defendant had sufficient ties to the community, then that individual could be tried in a tribal court. What occurred with that is that there were 6, in order to initiate that jurisdiction, there were 6 tribes that were picked as part of a pilot tribe. The Penobscot Nation was actually picked as one of the pilot tribes, but it was subject to the Maine Land Claim Settlement Act, which said if the state of Maine believes that it affects or preempts Maine law, then it has to weigh in and say whether or not the tribes could exercise that jurisdiction. And the state of Maine said they did not want the tribes to exercise VAWA jurisdiction at that time. And as a result, the Maine tribes were not able to exercise any of the VAWA jurisdiction. And it's important to know, when you're talking about VAWA jurisdiction, on tribal lands, the US Constitution does not apply. The Indian Civil Rights Act applies. And the Indian Civil Rights Act mirrors, and it actually contains some extensive, some additional enumerated rights that the US Constitution doesn't contain. It contains rights that were subsequently created by the Supreme Court, or penumbras of rights, I guess is what you'd say. So when we saw when that occurred, the tribes then moved in 2015 here in Maine to get the state to allow the tribes to exercise VAWA jurisdiction. There was a number of things that went back and forth between the states and the tribes on exercising VAWA jurisdiction. And the first time the legislature did not pass the bill, it was held over. Subsequently, it was reinitiated, and in 2019, the bill was passed that the tribes could exercise VAWA jurisdiction. But there were limitations that the governor sought to put on it, and so it was held over from the session and eventually sent back to the legislature. What came out of the legislature was a Maine VAWA that was significantly different in some ways than from the federal VAWA. The Maine VAWA required that the tribes exercise a 12-person, if they exercise tribal court jurisdiction over a non-native, that they have a 12-person jury. Under the federal VAWA, it's only a 6-person jury. The Maine jurisdiction contained a provision that required mandatory reporting to the State Bureau of Identification. Under the federal VAWA, there is no mandatory reporting. And this is probably the biggest difference. The Maine VAWA Act specified the specific crimes over which the tribe had jurisdiction. It limited the tribe's jurisdiction under the Maine VAWA Act to Title 17.8, Section 207A, which is domestic violence assault, domestic violence criminal threatening, domestic violence terrorizing, domestic violence stalking, domestic violence reckless conduct, and violation of a PFA. Those were the scope of what tribes could exercise a jurisdiction over a non-native of in tribal court. Under special domestic violence criminal jurisdiction, the DV crimes were not specified. The crimes, the general categories were specified, which were domestic violence, dating violence, and criminal violations of a protective order. But it was up to the tribes to define how those terms and what laws existed under those terms. And so the tribes could define what they wanted for what constitutes a domestic violence crime. And then the final difference was in the suppression hearings, the state requires that the prosecution must prove the voluntariness of an admission. And under the federal VAWA, the issue of a suppression hearing wasn't addressed, but presumably the defendant had to prove that the admission was involuntary. And so that was the state of the law. There are only 27 tribes in the United States that are actually exercising VAWA jurisdiction at this point in time. And that was the state of the law up until actually about 2 weeks ago, when the reauthorization of VAWA came out. The reauthorization of VAWA now specifically includes the Maine tribes, which is a provision under the Settlement Act that said that with the Federal Settlement Act that said 1735B, 1725, said that if the state, if the federal government specifically includes the tribes in Maine in the legislation, then it applies to the tribes in Maine, and it did. So the law we now have is going to, where the tribes will all be able to apply the federal VAWA law rather than the state VAWA law. The federal VAWA law is significantly more expansive now as far as jurisdiction goes. The federal VAWA law, which will is effective after October 1 of 2022, provides that child violence, crimes defining child violence, are now included under tribal court jurisdiction. Sexual violence are now included under tribal court jurisdiction. Stalking is now included under tribal court jurisdiction. Sex trafficking is now included under tribal court jurisdiction. Assaults of tribal justice personnel are now included under tribal court jurisdiction, and obstruction of justice charges are now included under tribal court jurisdiction. The crime, in order for the tribes to have jurisdiction, the crime still must occur in Indian country on tribal lands. the victim must be an Indian for most, but not all of the crimes, particularly the assaults of tribal justice personnel and the obstruction of justice crimes, do not require that the victim of that crime be a tribal member. And the defendant having ties to the community is no longer a condition of the exercise of jurisdiction. It used to be that you had to prove that somehow the defendant had some tie to the community, either they lived or had a relationship with an individual on tribal lands or were employed by the government, by the tribe. That's no longer the case. If somebody comes onto tribal land and commits one of the covered enumerated offenses, the tribal court can exercise jurisdiction. The definitions of those charges are left up to the tribes, which and to my mind, it's going to create a conflict, and I see the potential for a conflict with the state jurisdictional requirements, because the state requires under the Implementing Act, the tribes are all required to exercise jurisdiction over crimes that are identified by the state. And so, and when you come to tribal court, the tribes are required by the Implementing Act to exercise Maine criminal law as the law which governs in tribal court. Now you're talking federal preemption, which is saying the tribes do not have to live by at least for these areas, the tribes do not have to live by those definitions. They can create their own definitions of crimes. And for instance, one of the anomalies is the tribal courts only had jurisdiction over misdemeanor offenses until the Tribal Law and Order Act of 2010. So what you would see tribes doing, and the Lakotas did this at Pine Ridge, they actually had a murder charge that was a misdemeanor offense so that they could prosecute, and in fact did. They had a case where the federal government refused to prosecute a murder offense on tribal lands, and they prosecuted it as a murder offense under their tribal code. And so you see tribes doing that as they define the terms and you wish to exercise a jurisdiction. I think that there may be some challenges with regards to that, as far as how do you meld the two together, as far as Maine criminal law that the Implementing Act requires, and how do the tribes define the different categories under federal VAWA. Now, one of the interesting things that's really, I think it's a benefit, is that both the tribe and the state, they're dual sovereigns, and the dual sovereignty rulings from the Supreme Court have said that as dual sovereigns, their jurisdiction is concurrent, meaning that there is no double jeopardy. So even if you're tried in the tribal court or you're tried in the state court, if you're tried in the state court and acquitted, you can still be tried in the tribal court, and vice versa, as dual sovereigns. And the State VAWA Act specifically recognized that as a provision of concurrent jurisdiction in the State VAWA Act. To exercise the VAWA jurisdiction, there are a number of requirements that the tribes have to meet with regards to the DOJ. There are 13 questions that they asked of the pilot tribes, and basically those 13 questions they ask of all tribes before they exercise jurisdiction. I think the only real differences that you would see is that they require that the tribal judge be a law-trained judge. That's not something that you see everywhere. And the other really interesting one that I have never seen anywhere else in my career, 38 years, is that the tribal judge has to advise any individual that's brought to court under the VAWA jurisdiction that they have the right to petition for a writ of habeas to the federal court, and that not only do they have the right to petition for a writ of habeas to the federal court, but they have a right to seek a stay of any period of incarceration imposed by the tribal court during that petition for a writ of habeas. And the new provisions of VAWA 2022 require that not only do we tell them that as a tribal court judge, but that we get that in writing. So we're going to be doing a form that requires the individual to sign off and acknowledge that they have been advised of their rights to do so as far as that exercise of jurisdiction. I think that's pretty much what I have as far as a quick overview. If there's a specific area people want me to talk more about, I'm happy to, but I wanted to give everyone a quick overview and not take too much time.
Wonderful. Thank you so much. Questions for Judge Mehnert? Thinking about the expansion of jurisdiction. I'm going to say personally, jurisdiction stuff is something is an interest of mine. And one of the things I'm thinking about too is, so with this automatic, well, not this automatic stay, the right to petition for a stay. I mean, most of your litigants are represented.
We have a public defender at Penobscot Nation. We went with a public defender system. So we provide a public defender to everyone who is charged here. And we start at the arraignment level, actually, which we find to be, I do a lot of work. I travel around the country for the BIA, the Bureau of Indian Affairs, as a contract judge and doing court evaluations. And one of the things that we discovered in conversations with judges is that it really is probably much more effective to have a public defender than not, because we start them right at arraignment, and we can weed out a number of cases right away at arraignment. We don't get cases clogging up the docket with a public defender. They're pretty quick about, these are the ones that we're going to try. These are the ones that can be resolved. But yes, so we have a public defender that will take that right up through.
And so then on the other end of things, what can we anticipate the victim rights and victim services will look like in this process?
We actually just got our OVW grant, and we are hiring a victim witness advocate here at the tribal court. As you know, Penobscot Nation has its own DVSA advocacy center, and they work with victims all the time. But we felt the need to make sure that as they came into the court system, that there was a victim witness advocate that would work with them as they work their way through the court system.
That's great. Thank you. Looks like we have a question from Elizabeth.
I was just curious about what your process is going to be to define those offenses, and to what extent you are thinking about or supportive of or not supportive of aligning with the criminal code.
That really is a question for the chief and counsel as to whether or not they choose just to say we're going to keep the Maine criminal code, or whether they choose to say, no, we're going to define some additional ordinances. That process is different in every tribal community. Here there is a process that any laws that or code changes that are made are adopted by the general meeting, which is held once a year. And so it has to be first vetted by the chief and council, and then by the tribal attorney, and then it goes to general meeting.
Got it. And so typically those do end up being aligned in most cases, or
the Penobscot Nation oftentimes is aligned. In fact, there are 18 separate chapters. No, there's a little more than 18 now, I think. But the Penobscot Nation Tribal Code, which are found online, you can go to the tribal website and pick up the code. The biggest areas are about land use, which are uniquely tribal, and alienation of lands, and the Child Protective Code. But the nation chose to take its Child Protective Code and make it very similar to the federal code or the state code, because you can get Title IV-E money, which, because the tribes are economically disadvantaged, there's a lot of reliance on federal grant money and federal money to keep operations running. So it has been, oftentimes we do find ourselves, the nation does direct that they want the court to go to state law, But our defaults are, first we go to tribal law as dictated by the nation. Then we go to tribal custom and usage, which can come in if somebody has an expert. There are a couple of experts in custom. Then we go to federal Indian law, then state law. That's how it works down the system for us as far as applying the law.
Other questions or comments for Judge Mehnert?
I think one of the really interesting things about the nation is when I first got here, the chief said, "Oh, you're appointed." And I said, "Oh, that's great. Thank you." And he said, "We've seen how an Anglo court, now we don't necessarily want that. We've seen $350 fine next, $350 fine next. We want a problem solving court." And I said, "Great. What's a problem solving court?" And the chief raised his eyebrow and looked at me and said, "Figure out what the problem is and solve it." And it's been a really unique experience because it's given us a chance, and there's a lot that we get to work with here about trying out some interesting ideas and seeing if they work. And if they don't work, we can jettison them pretty quickly. If they do work, they are exciting to be part of because we actually do use a lot to solve problems here.
That's wonderful. Thank you. I'm mindful of the time and I'm wondering if it looks like Donna's here. And Donna is going to lead us in a closing ceremony for this week's Maine events. That is an offering of some staff and members of the Wabanaki Women's Coalition and some other tribal leaders here in Maine. And so before I turn it over to Donna, again, I just want to thank Judge Mehnert and Elizabeth and Fatuma for your time today. Thank you to everyone who has come and participated in these events over this week. And thank you to the folks on the Victim Advisory Board who helped to make all of this happen. I'm just the spokesperson, but there are a lot of folks who are involved in planning these events. And the final thing I'll say is just a real heartfelt thank you to our victim survivor service providers here in Maine. We are able to celebrate crime victim rights here because of the work that all of you do every single day on behalf of people who are hurt and harmed by crime. And so grateful for all of you and everything you do. With that, I'm going to turn it over to Donna.